AI y Fair Use. Una discusión en derecho comparado. Augusto Perera, socio de Augusto Perera PA, Estados Unidos. Mladen Vukmir, socio fundador de Vukmir y Associates, LLC, Croacia. Moderadora, Rosalía Ballester, socia directora en Ballester IP, España.
Muy buenos días a todos.
Good morning and welcome to this panel on AI and copyright and so compare law in the US and Europe. Thanks for being here, and also I want to thank our panelists, Augusto and Mladen. I would like to start by thanking ASIPI for inviting me to moderate this panel, and with such prestigious speakers. For a few days we have been talking about trademarks against public order and good manners and how PCT, etc. And today we have to talk about new technologies and specifically how AI is transforming the copyright world. This panel is especially motivating for two reasons. First, because it's a very updated topic, current topic. My daughter is working by the end of her career on the impact of data mining and copyright. And second, because as lawyer and agent of IP in Spain, with over 25 years of experience, I am starting with two certainties, based on two certainties. On the one hand, AI has changed the way the content since we have got into the fourth year of AI development. And on the other hand, we don't have yet clear in mind what happens with the contents that were used to have those ideas. Before starting, I would like to tell you how we will work on this at the panel. First, Augusto Perera will start. He will tell us about the North American aspect, and then Mladen Vukmir will talk about the European vision of this. Mladen conference will be in Spanish. If you want to listen to the translation, you have the headsets. At the end of both presentations, we have 15 minutes for Q&A. So let's start. Augusto, I wanted to congratulate you. I know that September you celebrated 10 years as a lawyer in Florida, and those who work in this profession, we know that starting and getting consolidated in a new land is always complicated. So, well, congratulations. Augusto is a lawyer specialized in IP and founder of his own legal firm in Miami. He held his career in the Office of Industrial Property. He's an active member of the bar in Florida, and he can work with the federal court and Supreme Court of the United States. He has degrees by Havana University. Augusto is an active member of organizations such as ASIPI, and has held positions of leadership in organizations such as Seashore American Bar Association and South Miami Kindle Association. Augusto, the floor is yours. Good morning. Spanish is my mother language, so I will speak Spanish. Thank you. As regards US, there's a lot of legislation as to AI and fair use. Copyright comprises many of the elements that we will discuss, and we will see not only, we will not limit ourselves to speak about the law, but some illustration of certain cases, recent cases. In the US, there's much jurisprudence or case law in this area, and cases such as AI, and under They're being analyzed under this light. Usually when we talk about AI models, we talk about high volume of data. This means that in order to train models, data need to be fed that will be used to generate the output when we interact with it. Since we have access to the data, having access to that data is important, otherwise it won't be generated. The question is, if that data that is fed, where does it come from? Do you have the rights? And in the US, it's very common that technology goes forward, then legislation comes out, and then companies say, start working on this, and then we will legally deal with the consequences. And this is what has been happening since this system was created about AI and training, which is essential. Without that training, AI could never exist. Usually when we discuss the first fair use in the US, we have to determine that there are certain regulations, federal law, that regulates everything in the US, and it states the guidelines when an analysis has to be performed, what is considered fair use, and the foundation when judges need to analyze a case that we will discuss. These are the foundations. The keys are very important to determine the conditions. One of the conditions is if the amount of work that was used. In the US, it is not mandatory to have works protected copyright to claim for copyright. But if you have protected it before the violation takes place, your rights will increase. This means that if you have your work protected, you can ask for minimum damage set by law. Violation starts in $750 to $170,000 per violation. So whenever you copyright a work, this will qualify for this. You can ask for damages, prejudices, and fees, professional fees, different from other countries that belong to Berna Treaty, since the treaty is ratified by the president back at that time, but it was not ratified by the Congress. And Berna Treaty is not self-executable. This means if the work is protected in your country, in order to exercise that right in US, that work has to be protected at federal level in the Copyright Office. And Supreme Court has made a decision back in 2018 that it has to, the right has to be granted. You cannot have an outstanding application on copyright. So the factors are pending there on the screen. You have the purpose of to use, if the work is protected or not, and the amount is important. This element as quantity has been very important in many of the cases that we will discuss, because it's not just a case of having 100 pages of a book with copyright. You can copyright just one page or a code or something very element. So this depends on the use that you give to it. Usually, and I will get into specific cases, many times when judges face new elements of technology, they have to go for those rules and case law to apply, or previous cases, and apply to this new progress. In the US, there's no legislation until a ruling by the Supreme Court is obtained. It's hard. So decisions of the judges will determine the guidelines or the considerations of the cases. First case that we will see has to do with Meta, Facebook. They created a platform, and they used, in this case specifically, certain works to feed that database in order to train it. In the specific case, this was 600 copies of a book, and plaintiffs said they were protected by copyright. Meta used the 600 books to create a copy of a bookstore or the library to train Llama system to train them. The case was determined. Meta was able to show that even when they copied the books, the violation to copyright in US is strict liability. This means that it's not very likely, it's very unlikely that you can justify the first use. Very difficult, so violation happened and it's over. You can justify that violation applies to first fair use. And in this case, Meta could demonstrate that even if they copied the books, the output did not reproduce those books. The books were just used to train the system so that it would be able to generate its own results without copying the books, without replicating the books and putting them available to for its use. In this specific case, the plaintiffs tried to push the system so that they would return as an output a copy of one of the books or a copy of a chapter of the book, and they were not able to get it. In this case, the judge stated that not only these are the factors of fair use, there's no violation because there's no affectation to the copyright, because this does not limit the right of the person who buys the book. Technically, the use given was just to train the system, but it does not generate a copy of that book. In this case, the decision was in favor of Meta. The other case that we have is Anthropic, with several cases that are still pending in the courts of the US. In this case, in the case of Bars specifically, they are a software company. Anthropic is a software company. And they used millions and millions, not 600 as a case of millions of books that were pirated. And pirated books means, books. Well, 10 years ago, Google tried to copy all the books and put them. Google had a lawsuit, and they tried to do the same and turn those books from digital books to submit those pirated copies into their system to train AI. They were able to show that in this case specifically, they had held copies of the pirated copies. This means that they used those works to train the system, but they were not holding the copies. They did not duplicate the copies of those books. And many of them that were pirated, they used them, but they did not have any copies in their servers they did not have copies of the books in their service. They were not able to replicate, as in the case of Meta. Those books could not be replicated as a result of that activity, the LLM, large language models. So due to this decision that the use was transforming, the court determined that in this case, the result was that it was a partial use of the lawsuit because the court determined that it was a transforming use of the copy of that work. In the next case, Google versus Oracle. Oracle has software that is used as the base or the foundation to write other software. In the case, Google copied the API instructions, code instructions that are copied to build another software. In the case of Google, they used it to copy or to create Android. In the case of Google, they copied those APIs, which are certain instructions. And in this case, the courts determined that the use Google gave to those APIs was to create a new thing. They did not replicate the APIs that they copied to return it, to go back and return it to a user. But by using those APIs, they built something totally new on top. And this was the transforming result of the work, the result that determined that Google would not have legal consequences in this case, or on this case. In this case, we're talking about the head of the office copyright, Miss Neville. The Copyright Office has issued 2 works on the use and protection of AI. In the first guideline issued in 2022, 2023, there were no consequences or claims, nobody complained. But the second guideline, companies, technology companies, specifically Elon Musk and Tesla, raised a complaint to Trump's administration. I had a meeting with her where she explained about the foundation of those guidelines. This gives a guidelines that states the copyright for the protection of what is generated by means of AI. US, in order for something to be protected, it has to be humane. What is generated by means of AI is not protected, cannot be protected under any concept. In other countries, input can be protected, but not in the US. One part of the guidelines states, or used to state, that the use by technological companies of copyright of this database, of these books to train AI was illegal. And they complained to Trump. He fired this person from the Copyright Office because it's not a constitutional element. It was an institution created by decision of the U.S. Congress. The head of the office, president can appoint that, and the Congress in the U.S. has the possibility to remove that position or not. The Copyright Office comes from the budget of the U.S., and they will locate the office in one of the offices in the Congress building. This decision is being appealed, and it's suspended by now, although she declared non-constitutional the president to remove her from her position. She stated that there was a political attack because of the decision of the office to state those guidelines or those concepts that technology companies would not be able to use copyright to train AI. That decision is pending of appeal because there are other 2 cases to the Supreme Court that are attacking the president's decisions, Trump's decisions that are non-constitutional, and she's waiting for that decision. In this case, another case, Anthropic, we are talking about the fact that they used the lyrics of the songs to train AI. In this case, an injunction was submitted to prevent this from happening. The court determines that in this case, there was a transformational element, a transforming element, because AI was not replicating the songs. They were just using the songs to train the system so that it would be able to generate a totally different output. So the injunction was rejected. It went back to the federal court that was managing it to continue on the normal case. In the case of U.S., when provisional orders of injunction is submitted, the intention is to prevent that something urgent that is happening, preventing from continuing. In this case, Anthropic was able to keep using the lyrics of those songs. Usually, when we're talking about something such as AI, we have to organize certain topics such as ethics differences, talking about global companies, also allowed by U.S. Maybe this is not the case in Europe or Latin America. We need to strike a balance.
There's another case that I've not been able to include here. It's an extrajudicial agreement between Warner Music and an AI platform. They agreed out of court to leave the case if the platform would pay for the use of those songs. It was not lyrics, but songs that were being copied to train AI. And the authors were able to say, well, I don't want my work to be used to train your system, so I have the right to decline. And they will have to pay. That's where we are heading in the U.S. Even if there is a negotiation between AI platforms and content owners to reach an intermediate situation where authors may be paid for the use of the works. Fair use is flexible in the U.S. if a court in the West. In the West, courts are more strict, unlike the East, but the court is there to make a decision when there are imbalances. Thank you. Thank you very much, Augusto. You've shared a clear vision of how this is tackled in the U.S. and the challenges that are faced in terms of innovation and rights. Our next speaker will talk about the European situation. Mladen, thank you for being here with us. We're happy to have you. We have congratulated Augusto, and we also have to congratulate you for your 35 years track record in your company. I'll try to read the Mladen CV, even though it's difficult because he has a long professional career. He specializes in IP. He's an attorney who founded his own company in 1991. He has a degree in law from Zagreb University and a master's degree in intellectual property from Flanking Pierce University. He's an agent of patents and trademarks, WIPO, IPO. He's also mediator with SIADE. He's been a mediator with several institutions. He has over 20 years of experience in mediation. He has worked with international companies and cooperated with WIPO, EU, European Commission, and the World Bank. He chaired ECTA between 2022 and 2024. He was a member of the Supervision Board and has held position at INTA and other associations. In 2020, he got the award of the INTA's president. Thank you very much, Rosalía. Thank you for this very interesting presentation by Augusto. I'd like to greet you. I'd like to thank the organizers for having invited me to talk about this topic in my city. I've been married to a person from Buenos Aires, so I feel at home here. But I'm going to speak in English because I'm also going to talk about concepts, and it's more difficult for me to do this in a language that's not my mother tongue.
To English. And a little overview of what is in store. First, I want to, normally I don't stress that the opinions expressed are personal, but in this case, because I represent ECTA here, I have to say that some of my ideas are somewhat controversial or radical, so I didn't even as a president of the association push too strongly for them. I have put in bold those that are of my greater interest, and you will see here that I want to look at the relation of AI and copyright. I think we don't do this enough as lawyers. We started already commenting on the cases and forgot that we didn't discuss the basics. I will present, however, EU legal framework just, superficially so that you can take home some ideas of what's going on. I will then zoom on a future regulation of AI and copyright, which is of my great interest because I think there is a feedback between the two that is going to bring changes. I will speak a little bit about transparency, and then I will lay out possibilities for alternative regulation models, and alternative I mean to what is now happening in the EU. And I will end on a conceptual note, talking about what is creativity and what are the limitations of copyright itself in respect to the new digital world. So, starting with the question, do we know if AI is diminishing or bolstering or changing human creativity in a way that that is transformative. That is what technologies do. Then there is this underlying question, can AI create at all, philosophically? Can it be creative? Or could it, if it goes further, and if we start using different technologies and not only LLMs? Then the question, how many humans create at the level of what AI can do today? You know, output, huge amount of output from humans is actually inferior to what we get from AI today. I also, in that light, you know, talking about the fair use and exceptions to apply to AI training, I think that Augusto did very well by pointing to the fact that we do have some problems. There is a tension between the public interest that these works are accessed, and you know, what do we do with authors then? I personally don't think that stretching copyright gives us sufficient answers. The question of compensation to authors is hanging out there as a big question, because if we go to these alternative models that I will just mention, by the end, you know, how we will compensate authors. Prior authorization and opt-out, is that a solution or is that a problem? I mean, we are not technologically there to be able to implement this. So the legislative solution mandating possibility to opt out, it doesn't seem to be catching up or seem to be working technologically. Yes, and then of course, the last one, the legal uncertainty of ownership of GI-generated content. Again, Augusto's pointed very clearly, you know, the US says it has to be human created. Humans claim rights on their creations. Machines don't. Why would we protect that at all, even if it is creative? So these are really questions that we don't spend enough time, in my view, talking about. So the EU legal framework is, you know, is it answering these questions that I mentioned? There is a set of existing rules that make a network, a mesh of regulations that influence what is happening, and many of you are aware that the EU is rethinking its approach and is, what is not here on the slide, the new omnibus regulations, the two regulations that have been proposed recently and that will probably pare down on the regulation-heavy solutions that were proposed originally. Then the uncertainty about what the text and data mining exceptions are. This is all being now before the courts, as I will show in the next couple of slides. Yeah, the opt-out. So one of the biggest cases is before the Court of Justice of European Union, and it's this Like Company versus Google Ireland. And the question asked by Hungarian court is for CGA EU to clarify the responses of an LLM-trained chatbot, which are identical to press articles. Does that constitute an act of reproduction? So yeah, legally, this is a fundamental question, and this is a very highly anticipated thing, but not before 27, apparently, according to the people in the know at the court. So, you know, the technologies change between 27, you know, we will have different ideas, and the industry will realign. So, you know, the whole legal thing, we have seen this with digital, you know, it doesn't perfectly align with the technological development and business models that are developing. One of the first national courts was, that was actually, I think, the first European case in general, was this before the Hamburg District Court, where there was the question of web scraping for compiling training data sets, and the answer of the court was that it does not necessarily represent commercial purposes on its own. There is another case on a Munich regional court where there is a question of processes within LLMs. Can they be classified as a reproduction? Then TDM limitations would not apply where systems are able to reproduce their training data. I don't know the specifics of technology there. Then a recent case in England, which was also very highly anticipated, and in a huge decision of, I don't know, 200 pages or something, the court seemed to indicate that there is no infringement. But the question is for which reasons? And again, there were some procedural reasons. There were some case specifics regarding technology. So yeah, we got an answer. It looks like a bombshell, big development. But then when you look closer, it is actually probably limited to the case. And one of my points as a lawyer is that we are looking at the cases too much. In modern societies, with complex business relations, with complex technologies, every case really is relevant only for that particular pattern. And the law is losing, in my view, ability to guide societies as it used when the whole structure of business and technology was way simpler than it is today. Now there are these two, I'm not going into them, they are popping up, there are more, I could add more. I mentioned the Denmark, because I'm Danish honorary consul, so I'm looking very with interest what's going on there, but I will not comment on them. I want to mention that EU does question in a way that I'm questioning, but again, not sufficiently in my opinion. And here are some political and scientific approaches. This Axel Voss is MEP, which is now very visible on AI things in the European Parliament. Then it happens that we are in the Danish presidency, or yes, for another month, Danish presidency of the Council of the EU, and they have a draft summary report on generative AI. There is this scientific thing that is very legalistic, and it actually indicates that whatever industry was hoping to cover with the TDM exceptions might not be applicable because of a complex legal interpretation here, which I'm not going to explain. But the last point, it is recommended to develop a licensing model that enables transparency and fair distribution, compensation, and enable effective negotiations with AI services. This is something I fully subscribe. I think this is proper framing of the questions that we have to answer. Excuse me. So, this is also not very relevant. I just picked it randomly from LinkedIn. There is a Turkish colleague who was at the several AI and copyright-related events, and including the big event in Alicante on 20 and 21st November, which I couldn't because I was speaking on the role of data in collecting management organizations in Zagreb on that day, so I couldn't go. But it was, his conclusion was that 2026 will be an important year for copyright in the EU, and I can't agree more with that. So there is other things going on. I was in Yokohama at AIPPI, as some of you were as well, and I participated in AI and copyright working committee. And there was an important publication resulting from this process or running in parallel. But in my view, it kind of stayed too confident that the copyright system can cope with this different circumstances that new technologies are bringing. So they relied very much on exclusive rights, and I don't think this will be as helpful as I'm not that optimistic, or I'm optimistic that we will have to make more changes to the legal framework. So there is this element of public interest that is lingering and being mentioned in many of the studies and many of the discussions. We need to go deeper on that. Transparency obligations on AI system developers. This doesn't seem to be happening really. You know, there's no response. Yes, there's demand by legislators, by authors associations, but it doesn't seem it's really resulting with something. So just in passing, Brazil also is adopting an opt-out system. I'm sure here are people who could give us more information. I didn't dig into it. And at the same time, Australia, that seems to be stepping away from the TDM exceptions. And Japan, which I didn't put on the slide, but actually in the Yokohama, we were discussing this. They are more liberal. They allow more access. So the countries are diverging. To me, it looks that Japan might have gave more thought to it, at least came to the most similar solutions to what I think is interesting. Probably fruitful, better say. Ensuring transparency, you know, here we spoke also among ourselves, also with Rosalía, what the technical measures, yeah, they are limited. This is not a bad idea that any author that has issue with his or her works being used can use some technical measures. And one of them, I will show you this here, robots.txt. And you see, this is an old technology. This is from the 90s, but that is supposed to kind of stop crawlers from approaching. Apparently, it doesn't work too well. I didn't really try it or whatever. So a voluntary model proposal is you know, I think that we will not be able to avoid talking more about it within different stakeholders, within the industry, legal community, cultural institutions of our societies. Yeah. So there is more and more talk about the sui generis. You know, there was also sui generis talk when the digital things started happening. Back, I'm talking about the end of 80s. No, there were countries such as Bulgaria at that time that enacted a sui generis software protection legislation, but you know, didn't go very far. There are challenges. If whenever you introduce something new, there is more uncertainty. Legal community tries to avoid it. You know, the industries need to move faster. But I think that in this case, that impact of AI is so profound that it might be worthwhile trying to think about the sui generis protection. And I will just mention, this is, in my view, also necessary because we developed two classes of intangibles. It's not only the intangibles based on creativity, which are protected by intellectual property. We have data, which is not based on creativity, and it's becoming rapidly more valuable than the human creativity. And it doesn't seem that protecting data with proprietary style protections is productive. Therefore, we have a tension in protecting intangibles in our societies that we need to really resolve because this new creativity or whatever it is, the output, is influenced by both data. Do we treat data, did we start treating creativity as data already in the training, you know? So it's not the creativity that's being used, it's treated as data. We don't speak enough about this thing. Well, go to the end. Yeah, what is creativity? This study where I took the illustration from is just, it says it's an insight-related neural reward signal. It says that creativity is an evolutionary trait that rewards us when we find a solution. So we enjoy it. So psychological definition of creativity might be very different. We need to reconcile this, the artistic, the psychological, whatever it can be. Then, if we ask ourselves deeper, will copyright start limiting human creativity in the new conditions? Then we have to resolve this, that there is a personal element to human creativity, which is protected by the moral right. And how do we resolve this with the human-centric goal of AI that the EU has? How to align this properly? Then something that is more controversial probably, I think that we made a mistake when we chose to protect originality in Bern's system. We were wrong from the outset. Nothing is original. So we were protecting the wrong value here. And AI seemed to understand this. It creates by using all this just like human artists do. The concept of creativity changed since Bern. Yeah, you see, Denmark, many of you might have heard, introduced copyright protection for human appearance, for your face. So we heard also about the personality protection in the previous panel. Previous panel tackled the likeness of voice, the Elvis Act in Tennessee that protects. So you see, copyright is being banned. It's not sufficient. And I will now explain why and then close. So you see, this quote is like 20 years old. I will read it because it might be too small. It's by Jim Jarmusch, the filmmaker. He says, "Nothing is original. Steal from anywhere that resonates with inspiration or fuels your imagination. Devour old films, new films, music, books, paintings, photographs, poems, dreams, random conversations, architecture, bridges, street signs, trees, clouds, bodies of water, light and shadows. Select only things to steal from that speak directly to your soul. If you do this, your work and theft will be authentic. Authenticity is invaluable. Originality is non-existent. And don't bother concealing your thievery. Celebrate it if you feel like it. In any case, always remember what Jean-Luc Godard said. It's not where you take things from, it's where you take them to." And that, who are we as lawyers to teach artists about creativity? So they seem to be more aware of the foundations of creativity than we are. And so I mentioned that the idea of creativity changed from romantic, gifted, individual, inspirational-based concept in the Romanticism at the time of Bern Convention. We know that today creativity is an ubiquitous knowledge-based activity of an educated individual. So it is profoundly different, So the idea of creativity changes along, and AI will change it much, much further. That's why I'm mentioning. Copyright never went really through this path easily. Copyright became an industrial property right, just opposite from what Bern Convention proposed. That was when entertainment industry started using copyright, and then software industry in the 80s. So it's not really serving the purpose that we devised it originally. I don't think we need to stick to this non-functioning system anymore. The digitalization brought, and I will not even open this, challenges that we didn't overcome. So, as you see, I propose to start protecting authenticity, the personal elements. I think that copyright will merge with expression, freedom of expression, and the free speech law. That will be new copyright that will protect authenticity. Will enforcement in the future be legal at all? Legal system doesn't seem to protect very well. As lawyers, what all we see is courts and cases. It seems like 100% of society is run by that. But actually, it's a very small part of society that is run by that system, So we kind of blind ourselves to the reality and to the role of law in the modern societies. So I will skip the idea of what I'm proposing and how likely is it to have some kind of a blanket levy protection for AI creative. So will the platforms, the AI platforms, have to pay whoever is registered as an author? I mean, these are two big questions. We can discuss them now because and that's thank you for listening to my dilemmas. Thank you.
Muchísimas gracias, Mladen.
Thank you so much. Mladen, we will open up Q&A. I think it's been very interesting to see the different perspectives and the way in which you explained, specifically, Mladen, the last part about protecting authenticity and not creativity. Is there any question?
Bien, pues, bueno, mientras veo que la gente se está un poco...
I see you're quite shy. I have a question for you. Oh, didn't see you had a question there. Yes, go ahead. I want to thank both speakers. I have been thinking for a long time of stating that AI is projecting us to a world where rationalizing law, looking for fundamentals or assumptions in it's just a game of parts in what we refer to case law. We need to get into something more philosophical. It's not just copyright, IP, authority or ownership. All these things are issues that if we take them away from the context, the world is in crisis, and the law avoids those crises. So we have to be quite careful as to raising all these barriers that will prevent us from killing ourselves or killing each other. The question is, if you think that stop discussing about case law and laws shouldn't be the next level of legal discussion and more philosophical or anthropological. Thank you. I believe we are in the field of Wild West at present. This is a situation where we are facing, I think we will get to a balance. I mean, protection, respect. In my opinion, I think we have to start by having respect on content, copyright, creators. The use of their works has to be respected and it has to be valued. And those new companies that are using those works without paying, they will have to compensate their authors. I believe if somebody remembers Napster, when Napster came, the process was an eruption until a balance came out. Technology has changed. To paraphrase a Cuban poet, those new companies, technological companies, well, AI will, as people says, the grass is always greener on the other side until you get to the other side. When those companies using these works without compensation, when they create something that they have to protect and they complain that others stealing from them, that's when they will learn how to respect. And they will start by respecting, paying, and using. That's my opinion.
Escuché bien la pregunta. Yo fui
I was not able to hear the question. There's some echo here, so I was not able to understand your question. Apologies. Are there other questions? Thank you. My question is brief. The distinction between original and authentic is not so clear to me, because originality may be objective, subjective. I'm not clear about the difference with authenticity. How can you see this difference in practice? You're right, because the idea of originality is subjective as opposed to objective novelty. But in terms of creation, the term has a different meaning. It's confused, and the courts 200 years later are not yet clear about that. With IP, we have a larger problem. 300 years later, the societies do not yet understand it. IP specialized courts are not there, which show that there is not perfect integration of intangibles as something people should own. I wrote something at the Journal of Property Law and Practice that will be published shortly. And in that paper, I talk about this. You're right that this has not been worked out. There is an overlapping, and I've discussed this with my friend Luis Schmidt from Olivares. We were Franklin Pierce classmates, and I talked exactly about that. And I think your question is a good question. I think that's not the only thing we have to change. We have to change other things, but I think it's a good question, and we'll see how this can be worked out.
Would you give our clients that are artists and that are now in this world and they're using AI, or probably they're the ones that their works are being used?
Yes. So Rosalía asked the same thing actually to both of us, and we gave it a thought a little bit. And you know, at this point of my career, I tend to give different advices than I used to when I was a younger lawyer. You know? So normally now I would say an artist, look, these are your risks, but you are due to follow your vision. It's not me who will determine what will you do, you know. So I just illustrate risks for them and say, deal with it. In another context, in an old-fashioned, more old-fashioned type, you know, I would tell people, okay, you need clearances for this, to using other people's work, you know. But, you know, don't bother too much. Just write to them. And give them 2 weeks. If they don't answer, you go ahead, you know, and you will show to the court if the cease and desist ever comes your way. You know, I will show, I wrote to the guy, you know, not my problem that they didn't answer. So I tend nowadays to find the ways to diminish risks for the clients, but not be too strict or too directive in what they should be doing.
Augusto?
Aquí hay una
Sí,
pregunta más.
para Estados Unidos,
In the US, you should protect your work. That's the first piece of advice I give to all artists. Protect your work, especially if you're a foreigner. Do not trust that your protection in other countries will be extended to the US, because without copyright, the copyright court will be closed to you. Thank you. There's another question here. I'm Gustavo Sena from Argentina, and I have a question for Augusto. Maybe I misinterpreted what you said as to everything that comes from AI in the US cannot be protected because it's not a human being. The guideline published by the Copyright Office says that the output cannot be protected. People are trying to modify this so that the inputs can be protected. But for now, there's nothing, and it's got to be human. 8 years ago, there was a photographer who went to a zoo and gave his phone to the gorilla. The gorilla took a selfie, and that's when Meta said that's copyright. But the Copyright Office said it's got to be human. Yes, I published something about that, and I said that if the gorilla would leave that park, then the gorilla owner would be responsible. So if it's responsible for any crime that may have been committed by gorilla, then that person will also be responsible for that picture. Same thing here. Behind AI, there are human beings. I think this is going to change. As far as I know, in China, the input can be protected. I think we have to reach a balance where authors' copyright are respected, but who will also go towards that path. AI is something that's being used by artists. Our customers are using. In Miami, I found restaurants with logos that look quite the same, and when I ask about it, I find out they've been created with ChatGPT. But currently, there's no protection for that. So it's going to be interesting to see what comes up in the future. I think duties, rights, and liabilities should be there in the same proportion. Agree? Are there other questions there? I'd like to make a comment about what Mladen said about the advice that may be given to artists who want to use AI. I'm not sure I agree with what you said, because I think we have to consider the respect for other people's rights. It's different from a tool, AI, which is a new tool today. So don't you think that we should use it cautiously? So as not to infringe anyone's rights, because if it's not done this way, I think AI will not be further developed. I understand your question, and I have my authenticity. I provide advice I believe in. I have a background in counterculture. I used to wear long hair and furs, long fur coats, and I do what I believe in. I respect other people's rights, but I'm not 100% sure as to whether the right owners always do the right thing. You may remember the case of the Danish artist and Louis Vuitton. those purses in Africa. That was freedom of speech, but I think that was trademark abuse. So I don't always agree with this doctrine about rights that cannot be infringed. I worked for large companies my whole life, and telling our artist clients, hey, there's a serious problem here because the owner is a big company or is aggressive. Once I worked with an airline company that wanted to use the term easy. And I said that will ensure an EasyJet lawsuit because they are very aggressive and they protect their brand a lot. So in copyright, every case is unique, always. And I believe that the certainty or the confidence we convey to our customers is false. Well, we've run out of time. You can get in touch with the speakers through the media, through their email account. It's been great to have you all here with us. I think both in Europe and in the US, the challenge we face is the same, finding a balance between innovation and rights in the fourth age of AI development. Let's have a strong round of applause for our speakers.